可以，对，可以继续 continue。
Okay.
你报告的非常好 ，your report is very nice and perfect, distinguished, good.
Okay. Okay. Who must prosecute criminal actions?
这次他就没有限制时间了。
对，因为你是不同的记忆体。
好 ，continue。
Okay, so according to Section 5, Rule 110
谢谢。
of the Philippine Criminal Procedure, all criminal actions must commence by complaint or information shall be prosecuted under the direction and control of the public prosecutor, meaning from the state prosecutor, and proceedings conducted in court in the absence of the prosecutor is void. In case this public prosecutors determine whether a prima facie case exists, decide which conflicting testimony should be believed, determine which witnesses shall be presented in court, determine what should charge and whom to charge. They can also be private prosecutor can also prosecute criminal actions with the following condition: either in case of heavy work schedule of the public prosecutor, meaning the state prosecutor, or in the event of lack of public prosecutor, private prosecutor must have a written authority by the Chief of Prosecution Office or Regional State Prosecutor and must be approved by the court. So usually it's the public state prosecutor who prosecute criminal actions. Okay. So how can we tell if a complaint or information is sufficient or if it's complete?
如你等一下，上面，在上面。各位嘉宾好，菲律宾有一个制度叫自诉检察官。自诉检察官是，如果是检察官工作非常繁忙，或是说缺乏检察官人力不够，自诉检察官必须获得检察长地区国家检察官的书面的那个授权，然后必须要得到法院的批准。它有一个叫自诉检察官，这个跟我们台湾的制度是不大一样的。OK, continue.
Okay. So according to Section 6 of Rule 110, sufficient complaint or information must have the following: name of the accused, it could be full name or nickname, or in case they cannot ascertain the identity of the person, they must describe in a fictitious name with a statement the true name is not known or unknown. Number 2, designation of the offense given by the statute. Number 3, acts or omissions complained as constituting the offense. It must include the aggravating and qualifying circumstances, if any, and also it must be stated in ordinary and concise language, meaning it should be the person should be able to understand what is the offense being charged against him or her. Number 4, name of the offended party. Number 5, approximate date of the commission of the offense. So the exact date is not really required unless the date is a material ingredient or vital information of the offense. And number 6, place where the offense was committed. So this is in compliance with the constitutional requirement. Section 14, Article 3. The accused must be informed of the nature and cause of the accusation against him. This is to enable the accused to make his defense and claim double jeopardy, just in case. Okay, so we will discuss crimes which requires primary investigation. So we now come to Rule 112, Section 1. So when is preliminary investigation required and what is the meaning of preliminary investigation? So Rule 112 defined preliminary investigation as an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed, and the respondent is probably guilty thereof and should be held for trial. So, this preliminary investigation is only conducted when the imprisonment or imposable penalty is at least 4 years, 2 months, 1 day or more, without regard to fine. So if it's less than 4 years, 2 months, or 1 day, it doesn't require preliminary investigation. There's also exception. Exception to 421 and up is when the respondent is arrested in flagrante delicto and undergoing inquest. So later, we will discuss this one. So, first step for crimes which requires preliminary investigation is the filing of complaint or information. So, with the proper officer for purposes of conducting preliminary investigation, the complaint must state the address of the respondent, accompanied by the affidavits of the complainants and his witnesses, as well as other supporting documents. So affidavit shall be subscribed and sworn, so it must be notarized before any prosecutor or government official authorized to administer oath, in such number of copies as there are respondents plus official file.
如你等一下哈，他这里有写注明受访者的地址应该是被告的地址，申诉人应该是原告，对不对哈？嘉伟同学哈，申诉人应该是原告，受访者应该是被告，对不对哈 ？Respondent 哈 ，respondent 好，继续。
So followed by investigating prosecutor's resolution. So it should be within 10 days after the filing of complaint. The investigating officer shall either do the following. So the state prosecutor can either dismiss.
Dismiss.
Yes, if he finds no ground for investigation, or issue subpoena to the respondent within 10 days. So second is there's.
等一下，这个解雇应该是不起诉了，继续，不起诉。
Okay, so within 10 days from receipt of the subpoena, the respondent shall submit his counter affidavit and that of his witnesses and other supporting documents for his defense. So the counter affidavit shall be subscribed and sworn to, and copies must be furnished to the complainant. So respondent is not allowed to file a motion to dismiss in lieu of a counter affidavit. MTD means motion to dismiss. So if the respondent cannot be subpoenaed or does not submit the same within 10 days period, the investigating officer shall resolve the complaint based on the evidence presented by the complainant. Okay. Then followed by clarificatory hearing.
等一下哈，如理，这个各位嘉宾好，这个反宣誓书啊哈，嘉玲你觉得这相当于我们这个什么哈？反宣誓书。被申请应该是被告了哈，收到那个检察官的那个传票，10天以内要提交其反证词，
答辩书吧，
答辩书了哈，其他辩护依据的证明，辩护依据应该就是被告的那个答辩书了哈，答辩书，然后被告不得提交 MTD
Motion to dismiss.
被告不能提交 motion 什么
To dismiss.
motion to dismiss 哦。motion to dismiss 哈，好 OK， 然后再提交被告提交那个辩护书那个辩词答辩状以后10天以内，好有40，好那继续 continue。
Okay, so after submitting counter affidavit, they will have the clarificatory hearing. So within 10 days from submission of the affidavit, the investigation officer may set a hearing if there are facts and issues to be clarified. So the part can be presented at the hearing without right to examine or cross-examine. However, they may submit questions to the investigating officer, which may ask to the party or witness concerned. The hearing shall be terminated within 5 days. So the next.
还举行听证呢哈，举行听证。
So within 10 days after the investigation, the investigating officer shall determine whether or not it is of sufficient ground to hold respondent for trial. So probable cause can be established with hearsay evidence because technical rules on evidence does not apply on preliminary investigation. So resolution of investigating officer. Must prepare resolution and information. So after investigation of the prosecutor, and if the prosecutor finds cause to hold respondent for trial, he shall prepare a resolution. He shall certify under oath the following information: that he has personally examined the complaint and its witnesses. There is reasonable ground to believe that the crime has been committed and the accused is probably guilty thereof. The accused was informed of the complaint and evidence submitted against him. Accused was given the opportunity to submit controverting evidence. Okay. The next is prepare and recommend the dismissal of the complaint. So either prepare resolution and information or recommend dismissal of the complaint. Where the investigating prosecutor recommended the dismissal of the complaint, and his recommendation is disapproved by the boss. The boss meaning either provincial or city prosecutor, chief state prosecutor, ombudsman, for offenses cognizable by the Supreme Sandigan Bayan. So these are the boss. So where the investigating prosecutor recommended the dismissal of the complaint and his recommendation is disapproved by the boss on the ground that probable cause exists, the boss may file the information by himself against the respondent or direct another assistant prosecutor without conducting another preliminary investigation. So whatever the decision, it should be approved by the chief prosecutor. The next step should be within 5 days from resolution, the investigating prosecutor shall forward the record of the case to the provincial or city prosecutor, state prosecutor, or the ombudsman, and they shall act on the resolution within 10 days from receipt thereof and shall immediately inform the parties of such action. So whatever the resolution, the respondent can file an appeal to the Secretary of Justice. So this is under the Department of Justice. The aggrieved party may file a motion for reconsideration within 15 days from receipt. And then the Secretary of Justice may reverse or modify the resolution of the provincial or city prosecutor and direct the prosecutor concerned either to file the corresponding information without conducting another preliminary investigation, or to dismiss or move for dismissal of the complaint or information with notice to the parties. And we now come to the filing of information to the court.
等一下哈，瑞，这个菲律宾的那个起诉啊，他有提到向法院提交资讯啊，如果没有得到这个主任检察官或者说那个检察长的那个首席国家检察官，相当于我们的检察总长哈，就是没有经过这样他的上级的 boss 哈书面的那个授权的话哈，这个调查的检察官，基层的检察官不能向法院这个起诉啊哈，起诉。所以一定要基层的检察官要起诉的话，一定要 get the authorization from his boss prosecutor. OK, continue. 要得到首席检察，这里有提到要首席这个调查检察官哈，如果真的要把那个案件向法院起诉的话哈，一定要得到首席检察官的批准哈，批准。谢谢。这个他们那个检控的非常管控的非常严格。
So after that, we now come to the filing of information to the court. So no complaint or information may be filed or dismissed by an investigating prosecutor without prior written authority of the provincial or city prosecutor or chief state prosecutor. So, information, it should be one information, one offense to avoid duplicity of the offense. So, a complaint or information must charge but one offense, except if the law prescribes a single punishment for various offenses.
Continue.
If there are amendments, these are the general rule for amendment. So, before the accused enters his plea, amendment may be formal or substantial without leave of court. After the accused enters his plea, only amendment as to form may be provided, and it should not prejudice the rights of the accused and with leave of court. And exception, if amendment downgrades the nature of the offense or exclude any of the accused from the complaint or information, amendment may only be made upon motion by the prosecutor with leave of court and with notice to offended party. And within 10 days from filing of the complaint or information, the Regional Trial Court, RTC, shall provide personally evaluate resolution of the prosecutor and its supporting evidences. So the judge is not required to personally examine the complainant or its witnesses, but he must not rely solely on the report of the investigating officer. He must personally evaluate the report and supporting documents. So, if there are no amendments or after any amendment, we now come.
等一下哈，法院收到检察官的那个起诉以后哈，法院就是命令检察官 provide more evidence， 第二个发出逮捕令 arrest writ， 然后呢或者 dismiss， 因为他那个证据不足的话，就是立即驳回 dismiss the case。 Okay, you can introduce the procedure.
So the judge could either order prosecutor to present additional evidence. So it should be done within 5 days.
5 days.
From notice, in case there are doubts on the existence of probable cause. So the issue must be resolved by the court within 30 days from filing of information. So issue warrant if the probable cause, or dismiss if no probable cause. So if there is probable cause, the judge should issue a warrant of arrest. If there is no evidence on record and fails to establish probable cause, the case should be immediately dismissed.
Really, one problem. Who have the power to issue the arrest writ? The court? 没错嘛哈 ，court 嘛，法官
Yes.
judge.
Yes.
Okay. Continue.
So execution of warrant of arrest. So the head of office to whom the warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days from receipt. So within 10 days from the expiration of the period to execute warrant, the officer to whom it was assigned for execution shall make a report to the judge who issued the warrant. So it's the court, it's the judge. And in case of failure to execute, he shall also state his reasons within the report.
To the judge,
Yes.
not to the prosecutor.
No.
To the judge.
Sure.
Okay. Continue.
So we now go to Rule 113 of the Criminal Procedure.
等一下哈，各位嘉宾好，如您现在介绍的是菲律宾刑事诉讼，新版修正刑事诉讼，他们没有刑事诉讼法，他们叫刑事诉讼 rule 哈 ，Criminal Procedure Rules 刑事诉讼规则113条。好 ，continue。逮捕 arrest。
Yes, arrest. So Section 1, Rule 113 talks about arrest or the taking of a person into custody in order that he may be bound to answer for the commission of an offense. So how is it made? So an arrest can be made by actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest. So Section 2, Rule 113 states that no violence or unnecessary force shall be used in making an arrest. The person arrested shall not be subject to a greater restraint than is necessary for his detention. So, warrant of arrest is valid. A warrant of arrest is valid until the arrest is accused. So, the report of a warrant of arrest shall only mean a report and will not affect the validity of the warrant of arrest. The court then, after the report, shall issue alias warrant. Again, please note that within 10 days of effectivity of warrant is subjected to search and not warrant of arrest.
Rudy. Okay.
So the warrant of arrest is valid until the accused. The warrant of arrest is valid until the arrest of the accused, and the search warrant is only valid for 10 days from its receipt. So, procedure to arrest. Section 3, Rule 113. It shall be the duty of the officer executing the warrant to arrest the accused and deliver him to the nearest police station or jail without necessary delay. So, Section 6 means that an arrest may be made any day at any time of the day or night.
Day or night.
Day or night.
晚上也是可以逮捕。
Any day or and any time.
Okay. Continue.
We also have what we call the warrantless arrest. What is warrantless arrest? So, according to Section 5, Rule 113, it is the lawful arrest without warrant. So, a peace officer or private person, meaning citizens, or private person's arrest or citizen's arrest, may without a warrant arrest a person. So, how is it made or when is it done, the warrantless arrest? So,
Rudy 就到这里就 OK 了。那我跟各位嘉宾报告，这个菲律宾的113第 5 the rule 113 the 5 section， 他说 no arrest。无令状的合法逮捕，所以我们那个大陆法系跟这个菲律宾的法系哈，他们都有一个叫做那个无令状的这个逮捕了哈，有一个无令状的逮捕，然后现场调查程序大概就是我们相当于我们那个刑诉的那个现行犯了，好，现行犯，然后可能原因的逮捕或追紧追哈，可能就是准现行犯这样哈，那他这里有提到一个无证逮捕，就是菲律宾新修正的刑事诉讼规则第113条第5节，无逮捕令的合法逮捕哈，就是不需要令状的逮捕了哈，治安官或私人可能发现现行犯的哈，治安官或者说公民哈，可以在没有逮捕令的情况之下逮捕现行犯这样。好，那非常感谢如您的报告，也非常感谢各位嘉宾还有研究生的聆听，谢谢。